Hey folks, Mark Scroggins with Scroggins Law Group. Today, wanted to continue on our discussion about mediation. And one question I get all the time is, why is mediation mandatory and what happens if we don't go? Okay. Well, the general reason that mediation is going to be mandatory in most courts is the courts have this idea that if you're going to take up our time asking for us to make a decision, we're going to force you to make at least one solid attempt at getting this resolved without it being on the court's time. Okay, so that is the general idea behind it. Now, what happens if you don't go? Well, it depends on the court. Most courts have a mandatory clause, and if you don't go, like in Collin County, for example, then you've got 1 hour to try your case. Well, if the case isn't, doesn't have a whole hell of a lot to fight about, that might not be a big deal. And actually, from a strategic standpoint, that might be a smart move. But most cases, are going to take at least a day or multiple days. And if you've got multiple days, trying to shove that through a funnel and try it in an hour is damn near impossible. So that's what happens if you don't go. So if a court orders you to go to mediation, by all means go. I can't tell you how many times I've gone to mediation convinced that there was not a snowball's chance that a case was going to get resolved, and it did. Conversely, I have been convinced that some cases were going to get resolved pretty easily in mediation, and they didn't. So what is the theme of all of this? If you're ordered, you need to go, but you need to make sure that you are prepared. And that sure as hell does not mean to stop preparing the case like you were going for trial because mediation is coming up, okay? It is not the be all and end all. And if you don't get resolved there and you haven't done what you need to get prepared for trial, you can be in a world of hurt. So before you get in that world of hurt, give us a call. We're here to help you.